Patriots, we have huge news in the fight to end the NFA. A new lawsuit just landed in front of Judge Matthew Kacsmaryk, one of the most pro-gun judges in America. And guess what? A viewer of this channel is the lead plaintiff. We're talking about Jensen v. ATF, the case that could destroy remaining NFA restrictions on suppressors and SBRs after Congress reduced the tax to $0. Judge Kacsmaryk has already struck down the ATF's pistol brace rule, 80% receiver rules, and more. Now he gets to decide if the NFA survives without a tax. But the Trump DOJ is fighting hard to defend the NFA. Before we break down this critical case, smash that subscribe button. One of you could be the next plaintiff in a landmark gun rights case. Let's get to 1.1 million subscribers. Let's dive into Jensen v. ATF. Judge Kacsmaryk, the pro-gun champion. First, let me tell you about Judge Matthew Kacsmaryk because his track record is incredible for gun rights. Judge Kacsmaryk sits on the Northern District of Texas, a federal district court that's become a major battleground for Second Amendment cases. His pro-gun record: struck down ATF's pistol brace rule, found it exceeded ATF authority; struck down 80% receiver regulations, ruled ATF can't redefine firearm; ruled against ATF overreach in multiple cases. Judge Kacsmaryk actually understands constitutional limits on government power. He doesn't rubber stamp ATF regulations like many judges do. He applies Bruen correctly. He requires the government to meet its burden of proof. He doesn't defer to agency expertise. When plaintiffs filed Jensen v. ATF, the case was randomly assigned to Judge Kacsmaryk. This is huge. Having a judge who understands gun rights and ATF overreach could be the difference between victory and defeat. The plaintiffs couldn't have asked for a better draw. The lead plaintiff, one of you. Now here's what makes this case extra special. The lead plaintiff, Mr. Jensen, is a viewer of this channel. That's right, someone who watches these videos is now the named plaintiff in a federal lawsuit that could end the NFA. This shows that anyone can make a difference. You don't have to be a lawyer or a politician to fight for constitutional rights. Mr. Jensen, along with other plaintiffs, decided to step up and challenge the ATF's remaining NFA restrictions. He's representing millions of gun owners who want to own suppressors and SBRs without unconstitutional government restrictions. This is citizen activism at its finest, taking the fight directly to federal court. So, Mr. Jensen, if you're watching, thank you for your courage and for taking this stand for all of us. The zero tax background. Let me bring everyone up to speed on why this case exists. Congress passed H.R. 1, the One Big Beautiful Bill, which reduced the NFA transfer tax from $200 to $0. This applies to suppressors, short-barreled rifles, SBRs, short-barreled shotguns, SBSs, and any other weapons, AWOs. This zero tax is now in effect. But here's the problem. While the tax is gone, all the other NFA restrictions remain. Registration with ATF, fingerprints and photos, months-long approval process, government tracking database, interstate transfer restrictions, 10 years in prison for violations. Gun rights organizations immediately recognized the opportunity. If the NFA was justified as a taxing measure and there's no tax, what's the constitutional basis? Multiple lawsuits were filed. GOA's case in Texas, SAF's case in New Jersey attacking state bans, and now Jensen v. ATF. The plaintiffs' arguments. Jensen v. ATF makes powerful constitutional arguments. Argument number 1. Suppressors are protected arms. The plaintiffs argue suppressors are safe, effective devices that reduce gunshot noise, used for lawful purposes like hunting and target shooting, protect hearing and prevent permanent hearing damage, reduce noise pollution, make training safer and more effective. Contrary to Hollywood movies, suppressors don't make guns silent. They're hearing protection devices. Criminals rarely use suppressors. The ATF's own data shows this. Argument number 2. SBRs are protected arms. Short-barreled rifles are clearly arms under the Second Amendment. They're not dangerous and unusual weapons, they're just rifles with shorter barrels. What makes a 15.9-inch barrel rifle dangerous but a 16-inch barrel rifle safe? It's arbitrary. The Constitution guarantees the right to possess these common arms. Argument number 3, no constitutional basis without tax. The Supreme Court upheld the original NFA in 1939 as an exercise of Congress's taxing power. The entire NFA was justified as a tax measure. But the big, beautiful bill eliminated the transfer tax. There's no tax on individual transfers anymore. If there's no tax, there's no constitutional basis for the registration, approval, and tracking requirements. Argument number 4. Exceeds congressional power. Congress's enumerated powers are limited. They can't just regulate whatever they want. The taxing power justified the NFA. Without the tax, the remaining restrictions exceed Congress's constitutional authority. The plaintiffs asked Judge Kacsmaryk to declare the NFA's registration and transfer requirements unconstitutional for untaxed items, enjoin the ATF from enforcing these restrictions, and end the NFA for suppressors, SBRs, SBSs, and AOWs. They filed a motion for summary judgment, asking the judge to rule in their favor without a full trial. Trump DOJ's defense of the NFA. Once again, the Trump DOJ is defending the NFA. Attorney General Pam Bondi and DOJ attorneys filed an opposition brief. They also filed their own motion for summary judgment, asking Judge Kacsmaryk to rule for the government. Here are the Trump DOJ's arguments. Argument number 1, there's still a tax. The DOJ claims that even though the transfer tax is zero, there's still a special occupational tax on manufacturers, dealers, and importers. They argue this remaining tax justifies all the registration and approval requirements, but this is absurd. The occupational tax on industry has nothing to do with requiring individuals to register their suppressors. Argument number 2, web of regulation. The DOJ argues the registration system creates a web of regulation that helps enforce the remaining occupational tax. But if there's no tax on individuals, what are they enforcing? This is circular reasoning. Argument number 3, Commerce Clause. The DOJ argues that even if the taxing power fails, Congress can regulate suppressors and SBRs under the Commerce Clause. They claim these items are manufactured and sold across state lines, so Congress can regulate them. But the Commerce Clause doesn't give unlimited power. Just because something involves interstate commerce doesn't mean the federal government can impose registration and approval systems. Argument number 4, dangerous and unusual weapons. The DOJ claims suppressors and SBRs are dangerous and unusual weapons that can be regulated. They claim these items are easily concealable and therefore dangerous. But suppressors are legal in 42 states. SBRs are commonly owned. How are they unusual? And easily concealable? An SBR with a suppressor is less concealable than a pistol. Argument number 5, Supreme Court precedent. The DOJ claims Supreme Court and Fifth Circuit precedent already upholds the NFA. But those cases were decided when there was a tax. The entire legal landscape changed when Congress eliminated the transfer tax. The Trump DOJ is desperately grasping at any justification to keep the NFA alive. Why this case is critical. Let me explain why Jensen v. ATF could be a game changer. First, perfect jurisdiction. Northern District of Texas is favorable to gun rights. Judge Kacsmaryk has an excellent Second Amendment record. Second, right judge. Judge Kacsmaryk isn't afraid to rule against the ATF. He's done it before with pistol braces and 80% receivers. Third, post-tax legal landscape. This is the first major NFA challenge to be decided after the $0 tax went into effect. The legal arguments are strongest now because the original constitutional justification, the taxing power, is gone. Fourth, summary judgment.
Both sides want the judge to decide now without a full trial. This could lead to a fast decision, maybe within months instead of years. Fifth Circuit appeal. Whatever Judge Kacsmaryk decides will be appealed to the Fifth Circuit. The Fifth Circuit has been increasingly pro-gun rights. They might uphold a ruling against the NFA. Sixth, Supreme Court path. This case could eventually reach the Supreme Court. With the Trump DOJ defending the NFA, the Supreme Court would have to confront whether the original constitutional basis for the NFA still exists. Seventh, parallel strategy. This case is part of a multi-pronged attack. GOA's federal challenge, also in Texas, SAF's state ban challenge, New Jersey, Jensen v. ATF, Texas, with favorable judge. Multiple cases increase the odds of at least one major victory.
The Trump DOJ problem. Let's be honest, the Trump DOJ's continued defense of the NFA is frustrating for gun owners. President Trump campaigned on supporting gun rights, yet his Justice Department is fighting hard to preserve NFA restrictions. The Trump DOJ has defended the NFA in the Peterson suppressor case, defended the NFA in Rush and Robinson SBR cases, defended the NFA against GOA's challenge, and now defending the NFA in Jensen v. ATF. Why? Possible reasons. Reason number 1, bureaucratic inertia. Career DOJ attorneys default to defending federal law regardless of administration. Reason number 2, political calculation. Fear of being blamed if NFA is struck down and something bad happens. Reason number 3, prosecutorial interest. Federal prosecutors don't want to lose NFA charges as tools. Reason number 4, ATF pressure. The ATF doesn't want to lose regulatory authority. Whatever the reason, gun owners are disappointed. We expected the Trump administration to be on our side. What happens next? So where does this case go from here? Immediate future. Judge Kacsmaryk will review both summary judgment motions and decide. Option 1, rule for plaintiffs. Judge strikes down remaining NFA restrictions for untaxed items. Huge victory. But DOJ would immediately appeal to the Fifth Circuit. Option 2, rule for the government. Judge upholds NFA restrictions. Plaintiffs would appeal to the Fifth Circuit. Option 3, deny both motions. Judge says case needs full trial with evidence. This would delay resolution for months or years. Timeline. Summary judgment decisions can take weeks to months. Judge Kacsmaryk might rule quickly given his track record. Appeals. Whatever he decides will be appealed. This case could be in the Fifth Circuit by mid-2026. Supreme Court. Eventually, this issue must reach SCOTUS. The fundamental question, can NFA survive without a tax, needs final resolution. What gun owners should do. If you want to support the fight against the NFA, here's what you need to do. First, support organizations like GOA, SAF, and FRAC that are fighting these battles. They need funding for attorneys. Second, stay compliant with current NFA rules. Don't violate restrictions before they're struck down. Third, follow this case closely. Judge Kacsmaryk's decision could come any time. Fourth, prepare for victory. Research suppressors and SBRs so you're ready when restrictions fall. Fifth, spread awareness. Most gun owners don't know these legal battles are happening. Sixth, consider becoming a plaintiff yourself. Organizations need good test cases with good plaintiffs. All right, Patriots, that's the breakdown of Jensen v. ATF, the case where a channel viewer is fighting to end the NFA. Let me summarize. Jensen v. ATF challenges remaining NFA restrictions after $0 tax. Assigned to Judge Kacsmaryk, pro-gun judge with great track record. Lead plaintiff Jensen is a viewer of this channel. Both sides filed for summary judgment, fast decision possible. Trump DOJ defending the NFA again despite campaign promises. Could reach the Fifth Circuit and Supreme Court, part of a multi-pronged strategy to end NFA restrictions. The fight against NFA tyranny is accelerating. With the $0 tax now in effect in cases in favorable jurisdictions, we have the best chance in decades to end these unconstitutional restrictions. If you found this valuable, smash that like button, share with every suppressor and SBROer, subscribe for updates when Judge Kacsmaryk rules. Comment, do you think Judge Kacsmaryk will rule against the NFA? Should Trump DOJ switch sides? Until next time, stay armed, stay free, and never stop fighting unconstitutional gun laws. God bless Mr. Jensen and all the plaintiffs fighting for our rights. God bless America.